Good morning, Mr. Child. So you're charged with assault of a family.
Quick legal note: at a probable cause stage, the judge isn't proving guilt, they only decide if there's enough evidence to move forward. That Uber driver's description, someone seeing a punch and fall, can be powerful even if the victim later says she won't press charges. Reaction: that's a classic people change their mind moment, but the camera of probable cause is already rolling. Question for viewers: if you saw this happen in an Uber, would you step in or call for help? Transition. Next, watch how the court weighs witness description against lack of visible injury.
Remember, you're facing up to a year in jail and or a $4,000 fine.
Officers were dispatched to a disturbance at 70 Carlton Woods Creekside. Law enforcement officers observed a white male sitting on the curb of Kukendall Road, arguing with his girlfriend on a cell phone. Law enforcement officers had received an additional call of a disturbance of two individuals coming from a neighborhood party. They observed the complainant and defendant to be highly intoxicated. An Uber had picked them both up, and they both started fighting in the Uber. The Uber drivers pulled over.
Fighting in the Uber?
In the Uber, yes, Your Honor. The Uber driver pulled over. The Uber driver stated to officers that the defendant was slapping and punching the complainant, who was the defendant's girlfriend. And the Uber driver had called the security officer on duty to get help with the situation. I'm sorry, Your Honor, it's reading directly.
DVD's here. I don't know if Sebastian's had a chance to even look at it yet.
Actually, stay close to that area, will you? Don't come here. Stay close to that area.
Okay, sorry.
So we're just doing PC. All I've heard so far is that they're both highly intoxicated, arguing. He's allegedly punching and slapping in an Uber car. That's all I've heard so far.
So then Uber driver pulled over, called the security officer on duty. But the defendant got out and started walking. The security guard followed him until he got to the beginning of the subdivision. Then officers arrived and observed the defendant on the sidewalk. Officer tried to talk to the defendant. Once the defendant started to tell the officer, quote, "Leave me the fuck alone. You people are a piece of shit, and that's all you'll do is treat people with no respect." The defendant started walking towards the officer, dropped the pill bottles, and kept saying, "Leave me alone, get away from me." Officer asked the defendant what it was that they're trying to hide. Defendant said that that's my marijuana. Defendant was combative, telling the officer to fuck off. Officer made contact with the complainant witness, said they were a party, they both got drunk and started fighting when they got in the Uber. And the complainant witness stated that she did not feel pain. I think that's what we're at.
Do they see any visible injuries, anything of this nature?
As far as that goes, what's in the DIMS here is that the witness stated that he observed the defendant with enough force that she covered her face, fell to the floor, and that the witness observed the complainant based on her actions to appear to be in pain. Specifically that the punch was of such a force that it caused her to fall to the floor of the vehicle and cover her face after she was punched. So I think that's where we're at with that.
Again, Judge, to answer your question, there's no indication that there were any injuries at all, any marks, and as he just read, she said she did not feel pain, she did not want to press charges, and I have an affidavit on prosecution as well that I'm going to be getting to the state.
Yeah, so as far as bodily injury goes, of course, we don't need necessarily direct evidence. Pain can be something that can be inferred based on conduct. We understand that, a punch of a certain amount of force from a witness's perspective.
Did they get any statements from the person who saw the punch to?
Again, that was the Uber driver. And that's what the Uber driver said, that based on what they saw, the punch had enough force that it caused her to fall to the ground, covering her face.
The officer goes to interview the complaining witness, I'm
Yes.
assuming, and doesn't see
And
anything?
I don't see any indication that they saw anything.
And she says, I felt okay. And I do not want to press charges.
Mr. Child, there are people in life when they drink, they're the life of the party, they're fun to be around. And then there are those when they consume alcohol, they turn into aggressive, mean son of a bitch that just They have no business drinking. If this is you, don't drink. You have but one life. You start racking up cases, you start racking up convictions. All you're doing is you're hurting yourself. You know, be nice and good things happen. You're aggressive to cops, you're aggressive here. I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over. But don't drink if you're going to be in jail. You know, really, we have enough death and dismemberment in our city now as it is. Don't be on the news. All right, I'm going to find no probable cause.
Thank you, Judge. Judge, okay.
Speak English, sir.
Judge,
You like a translator, or do you speak well enough?
no, sir. I'm good.
All right, Mr. Octaviano, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On April 11th, 2025, in Harris County, Texas, officers dispatched to a motor vehicle accident. Upon arrival, officers observed an individual standing on the passenger side of the motor vehicle talking to several McDonald's employees. The defendant confirmed to officers that he was driving the motor vehicle that was present. Another officer verified the defendant was driving by talking to witnesses on scene who stated that they observed the defendant exit the motor vehicle from the driver's seat and was the only occupant of the motor vehicle. Let's see. The accident occurred in the 10,100 block of Hammerly Boulevard, Houston, Texas. I'm just trying to get some details on the accident, Your Honor. Officers observed the defendants have
Legal clarification breath results, e.g., 0.2215, and field sobriety failures, HGN. Walk and turn, create a stacked probable cause picture they don't convict. But they give the judge strong grounds to bind over. Reaction, from I had nothing to drink, to a double-digit breath result classic courtroom whiplash. Engagement question, have you ever seen someone insist they were sober while the tests say otherwise? Transition, the judge follows up with strict bond conditions. Watch how that tightens the timeline.
trouble maintaining his balance, slurred speech, and drowsy eyes. Defendant initially stated he had nothing to drink, then stated he had Buchanan's, but not too much. Defendant stated he had eaten a torta, but could not remember where it was from. Standard field sobriety tests were conducted with the following results: 6 of 6 HGN, 7 of 8 walk and turn, 3 of 4 one-leg stand. DIC was read. The defendant consented to a breath test. 0.202 and 0.195 were the results.
Said anything about driving? Did anyone? I
So,
know you have the admission, but
right, and they said there was several witnesses that saw him. I'm checking now to get some details on that actual accident, Your Honor.
you have witnesses that put him driving.
Yes, Your Honor, there was officers there that saw him.
I don't know if those witnesses are named, Your Honor. I haven't had a chance to look at the offense report.
Well, I'll give you time. This is just a probable cause hearing, you know, if it goes, right. Mr. Octaviano, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
Does he have a valid Texas
He does,
license?
Judge.
You cannot drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, do not drive. That is also a condition of your bond. Do you
Yes, Your Honor.
understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but you must stay in touch with counsel and he'll tell you if and when you have to come back to court. For now, we'll have you go sign a reset. We'll have you get with pre-trial for your bond conditions, then you're free to go.
All right, thank you, Judge. And I've got one more arraignment, Judge, but I think we're waiting on DVD on that one.
Okay.
So.
Yeah. Good morning, Mr. Berryhill. Good morning. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a disturbance call and made contact with the complainant, who stated that the defendant came into his business and was upset that a check issued to him was not good. Upon arrival, the defendant became belligerent with law enforcement officers, and complainant stated he no longer wanted the defendant on his property due to his aggressiveness. Defendant stated he was not leaving until he got his money and was advised 3 times to leave. Defendant refused to leave each of those times and was detained by law enforcement officers.
Okay. Mr. Berryhill, I'm going to find that there's sufficient probable cause to go forward with your case. Do not go back to this place. Do not have contact with the complaining witness. Do you understand, sir? Yes or no?
Yes,
Okay. Do you have the ability to hire a lawyer?
yes, I would like to have a lawyer. I would like a reset, have a lawyer.
Sure. We'll give you a reset now. I'm going to have the state create bond conditions for you. Don't go back to this business. Don't have contact with the complaining witness. As long as you can comply, you and I will be best friends. Otherwise, it's just not going to go well. Do you understand? Don't pick up a new case. Don't become a danger to my city. That's all I'm asking you to do. Do you understand? So I'll have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and then you'll be free to go. Please. So can you file no contact, no going back?
Absolutely.
You are Mr. Saran.
Yes,
Sir,
sir.
you're charged with criminal trespass, facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Law enforcement officers received a call for service where an individual stated that somebody was trying to break into her home. Officers observed the defendant matching the description given by a caller around in the area. Officers made contact with the defendant and he was identified by previous booking videos as well as his SPIN number. Officers made contact with the complainant on scene, who advised that the defendant was trying to break into her home. Complainant stated the defendant knocked on the front door, rang the doorbell, and looked through windows of the complainant's property. Complainant observed the defendant enter her backyard, stand on top of a shed to look into windows, and attempt to pull on a door handle to open the door.
And it's only a trespass.
Complainant has surveillance footage of the defendant on her property. Officers searched the defendant and found an unused pipe that officers' training experience indicates it was used for meth. Defendant stated he was a frequent user of methamphetamines. Defendant further stated that during an interview with officers that he was looking for items of value at the above residence in order to obtain money for drugs since he was currently out of money. And I think that the reason it wasn't charged as a bird cab is because he wasn't actually able to make entry into the residence.
Mr. Saran,
Yes, sir.
since 2023, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and now 11 in a matter of 14 months. If I find that you're using any kind of dope,
Clarification: repeated offenses change the court's playbook. Judges can use bond conditions GPS testing not as punishment but to protect the community and ensure compliance. Reaction: that horn and tails line? Judge level intimidation technique. Engagement: viewers, do you think GPS monitoring is fair for nonviolent offenders, or is it overreach? Quick transition. Next, notice how the court moves from warnings to concrete, enforceable conditions.
I'm going to take care of it in a way that you're really not going to like it. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. You're ordered not to use anything. And if I find that you do, and if I find that you become a danger to my community, I will grow a horn and tails. Do you understand?
Yes, sir.
I'm putting a GPS monitor on you so I know where you are at all times, and I don't want you out in the middle of the night.
Yes, sir.
It's time for you to stop using. I'm giving you now the opportunity to do it on your own. If you're incapable of doing it your way, then we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Please appoint him a lawyer. I'm sending him now for a drug test. You were to go test, and you were to come right back. I just want to know what, if anything, is in your system.
Yes, sir.
If you fail to test, if you fail to come back, I will issue a warrant. No more PR bonds. Do you understand?
Yes, sir.
Take a